Good morning, good afternoon, good evening to all of you around the globe who are attending today's webinar. This is the fifth in a series that was launched by the World Commission on Environmental Law 3 months ago. We are so glad you could join us this morning in Hawaii time. I'm Denise Antolini. I'm the Deputy Chair of WCEL, the World Commission on Environmental Law, and I'm a professor of law at the University of Hawaii, William S. Richardson School of Law. I will be introducing the webinar and covering some logistics for about 8 minutes before my dear friends and colleagues, Justice Antonio Benjamin, Chair of WCEL, and Dr. Stefano Burki, your moderator for today's webinar, begin the session. Tenemos interpretación simultánea al español. En la parte inferior de su pantalla, haga clic en el mapa mundi y le aparecerán los idiomas, elijan Spanish para español. To start, we hope you, your families, colleagues, and communities are as safe as possible during this difficult time. We are honored that you've chosen to take time away from your very busy lives to spend the next hour and a half with us. Whether you're in your living room, your home office, or like me in your kitchen, we're very happy that you could join us. The World Commission on Environmental Law is one of the 6 expert volunteer commissions of the International Union for the Conservation of Nature, the IUCN. WCEL is delighted to offer you this 5th webinar in its WCEL webinar series. This session is entitled Judges as Guardians of Water Resources, the Brasília Declaration of Judges on Water Justice. You will hear some fascinating insights into the fast-moving legal issues around water and the role of WCEL and the Global Judicial Institute on the Environment, the role that they have played in developing this declaration and a new global conversation about water law. So let me introduce very briefly the Commission and the Institute. The World Commission on Environmental Law is a volunteer network of environmental law and policy experts from all regions of the world who volunteer their knowledge and services to IUCN activities and other partners. We have over 1,300 members, many of whom are attending today's webinar, which has over 300 participants registered from all around the world. The Global Judicial Institute on the Environment is an organization launched 4 years ago by WCEL and key partners, by judges and for judges interested in environmental law issues and who serve on environmental courts and tribunals. It is dedicated to the development of dialogue and information exchange among judges around the world on environmental law issues. You will hear from several of the founders of the Global Judicial Institute on the Environment in today's webinar. So please go to the WCEL page of the IUCN website for updates, news, resources, and more information about WCEL, GGIE, the Institute, and also IUCN. Now, if you look in the chat box now at the bottom of your screen, put your cursor on the bottom of your screen, you will see the information, the websites for these organizations. And we will post there more general information throughout the webinar for your information from time to time. So keep an eye on the chat box. As many of you know, WCEL had planned to host the 2nd World Environmental Law Congress with many partners during a full week of environmental law events in Rio de Janeiro, Brazil in March of 2020. Unfortunately, due to the global COVID-19 pandemic, like many other organizations around the world, we decided to postpone our Congress to a future date until conditions would allow. You are also probably aware that because of the pandemic, the IUCN as a whole has postponed the major World Conservation Congress that was to take place in Marseille in June, and it will now be held in January 2021 in Marseille. So please check back on the websites for more information about these events. While these congresses have been postponed, our work, our challenges, our opportunities have changed, but they have not diminished our obligations to keep things moving. Our days are filled with calls and meetings and Zoom and other platforms, and we try to stay connected with family, friends, and colleagues. We've seen incredible pictures from around the globe of nature rebounding while we humans try to stay at home. We've seen unimaginable photos of clear water and freely roaming wildlife in places not seen before. Yet we're also witnessing tragic human health crises, social collapse, and shocking backsliding on environmental progress. So our communities, governments, organizations, and the entire field of environmental law must also adapt to these multiple unimaginable challenges. So this webinar series was created precisely for that reason, to keep the momentum going toward a better world, to encourage you, our members, partners, and colleagues around the globe to share conversations, to share expertise, and to press forward on a just transformation. Topics like water justice on the topic of today's webinar is urgent. So we must keep hope alive for the rule of law and a better world. It is our collective responsibility to keep the conversation going. We'll have more webinars in the future, so keep an eye out and we'll keep you posted. One more minute of housekeeping before we start. Some of you are Zoom experts. For some of you, this webinar might be the first time that you're learning various functions. So let me review some of them so you can stay very engaged. So what you want to do is keep that chat box open at the bottom. As I mentioned, you will periodically see some information posted there. You cannot chat back to us, however, so to communicate with us, the panelists, you will need to use the question and answer box, also at the bottom, Q&A. So if you want to submit a written question to the hosts and panelists, which we welcome, type a short question in the Q&A box. You can type in English or in Spanish. You can find that box at the bottom of your screen as well. So go ahead and find it now, so you can keep your chat box open and your Q&A box open. And you can type a question at any time. We may not answer it right away because we're going to be saving as many questions as we can for the question and answer session at the end. But we will also try to type some quick responses as much as we can throughout the webinar. So pretty soon I'm going to fade into the background as your background host, and your moderator, Dr. Berkey, will be assisted in moderating the webinar by several very important people. Emily Gaskin, an environmental lawyer who is the executive officer for WCEL, and Gayatri Naik, an environmental lawyer and PhD candidate at the School of Oriental and African Studies at the London School of Economics. She's also a member of the WCEL Water Specialist Group. Emily and Gayatri will be in the background assisting with all the questions and answers, and they've been invaluable in helping us prepare for today's webinar. I want to highlight another innovation today in our webinar series. For the first time, we are offering live interpretation in Spanish and English. You could tell from my halting Spanish at the beginning to try to get those who are Spanish speakers to open up that interpretation service. In the future, we also plan to offer French-English interpretation. So we're very honored today to be joined by two very experienced interpreters, Claude Arau from Uruguay and Etienne Van Damme from Argentina. And we're grateful for their expertise and assistance. So how do you access interpretation? Go to the bottom of your screen. You will see an icon of a world map just near the Q&A button, and click on that map to select your preferred language, Spanish or English. By default, you will hear the interpreted language at 80% volume and the original language at 20% volume, but you can also mute the original audio. So we hope that that works for you. Just a couple more reminders. We are recording this webinar, and we will share the recording later with everyone who has registered. We'll be sharing the PowerPoint and selected materials with you, and all of that will be posted on the WCEL website along with the other webinar materials. Last, I must add that the views expressed today represent the individual speaker's views and not necessarily the position of the Commission. and it does not present any official position of the Commission or of IUCN. It's purely educational and the speaker's perspectives, and we hope inspirational. Okay, my host duties are almost ending. I want to introduce two wonderful colleagues. First, you will hear from Justice Antonio Benjamin, the chair of WCEL for the past 8 years. Justice Benjamin is a globally recognized leader of environmental law from his many years as an environmental prosecutor in Sao Paulo, and since 2006 as a sitting justice on the National High Court of Brazil. We're very honored he has a few minutes to join us today to give a brief background on the Brasília Declaration, an initiative that he conceptualized and spearheaded successfully through its launch in March 2018 at the World Water Forum. After Justice Benjamin, you will hear from Stefano Berchi. Let me introduce him briefly now, so then Antonio can turn it right over to him. Stefano will introduce the panelists. Dr. Berchi is the chair of the WCEL Specialist Group on Water and Wetlands. He is an internationally recognized expert in comparative and international water law. From 1983 to 2008, he served in the Development Law Service of the UN Food and Agriculture Organization, where he concluded his tenure as service chief. He is chair of the International Association for Water Law, and he served on the drafting committee for the Brasília Declaration on Water Justice over many months, along with many distinguished colleagues, including our panelists today, helping to shepherd it through to a successful launch at the World Water Forum. So Justice Benjamin, Dr. Berchi, thank you so much for joining us. I'm going to turn it right over to you, Antonio, and thank you for joining today's webinar.
Good morning. Can you hear me?
Yes, go ahead.
Yeah, good morning, good afternoon, good evening, everyone. It's a great pleasure to participate in this webinar. Let me thank the team that organized it, especially Professor Denise Antolini, Emily Gaskin, and Stefano Berchi, and of course, the panelists that are here with us today. My task in 10 minutes is to give you the historical background of the Brasília Declaration of Judges on Water Justice. As it happens with products of this nature, a lot of it has to do with opportunities that come up. We can call them nice accidents. And in this case, Brasília hosted the 8th World Water Forum, and the main organizer was the Ministry of Foreign Affairs of Brazil and the National Water Agency. So I was visited at my chambers by two very senior Brazilian diplomats, Ambassador José Antônio Marcondes de Carvalho, at that moment the chief environmental negotiator of Brazil, and now ambassador of Brazil in Austria, and Ambassador Reinaldo José de Almeida Salgado, at that moment the head of the organizing committee on the Brazilian side of the 8th World Water Forum. And now he is the head of the division on Asia, Pacific, and Russia in our Ministry of Foreign Affairs. So basically, they wanted to know, because they were aware of the Global Judicial Institute on the Environment and the work that we had done in Brazil in making it the foundation of the Institute happening, whether we could bring judges for the first time to the World Water Forum. And I thought that could be a good opportunity for the judges to meet under the auspices of the Global Judicial Institute as well. Later on, I thought it would be good to have a product. So I began discussing with colleagues, and I approached Professor Stefano Burki and other colleagues individually, especially of the ones that are here, Justice Brian Preston and Michael Hankte. At that moment, Michael Hankte was still a justice at the Environment Court in Chile. And we put together a group of experts, both judges, since the declaration it would be won by judges, and the very best experts on water law and environmental law that we could find at that moment, and that were interested in working with us. We later on discovered that we had many more experts on water that we were not aware of, especially Professor Maria del Pilar, the outstanding scholar in Latin America on water law. But this team began working, and to my surprise, because frankly, I was not sure whether we would achieve any meaningful product, we were able in around 8 months, using Skype, not Zoom, to come up with a text that you have in front of you. The text was further reviewed during the 8th World Water Forum proper, but the skeleton is basically the one that was drafted by those leading judges and senior judges with strong expertise in environmental law and water law, and also our colleagues from academia. And behind all this, we had Professor Denise Antolini making sure that everything would be in place in terms of organization. And we are very, very grateful to her and to the other colleagues of the steering committee of the World Commission on Environmental Law. Let me now just highlight from my perspective as a Brazilian and a judge 2 points in the declaration, 2 or 3, that to me are very important. One is that if you go to the very end of the declaration, you see that the declaration is presented as a sort of summary of the best practice on and theories on water around the world, but it's also a cutting edge document. So we incorporated the very best, but we went beyond the very best that is in place and brought in new ideas. And you can imagine how difficult this is doing on a global scale with countries that are common law, others are civil law, Islamic law, and different legal traditions. And water, as we know, has been with the legal system from the very beginning of civilization. So at the very end, this cutting edge document done under the umbrella of the Global Judicial Institute on the environment with the partners, UN Environment, WCL, the Organization of American States, is presented to the judges. And there is a request at the very end that the Global Judicial Institute on the Environment approve the declaration, which was done. And of course, I think it's implicit to this that takes the lead in presenting it to judges around the world. That's something we are doing. The other 2 points that I would like to highlight have to do with the principles themselves. the principles are of general nature, and there are two that resonate directly with the work that I personally do as a justice, but also as a law professor. In principle one, you see the ecological function of water resources. So this concept borrows from the ecological function of property rights, here adapted to the water context. And Professor Maria del Pilar will be able, I suppose, to say more about the ecological function of property rights, because it's directly and expressly stated in the Colombian Constitution. So this is in principle 2. And in principle 6, a term that I coined in my country, and I share this with our colleagues, and it was immediately, it resonated with everyone, which is the in dubio pro aqua principle. We wanted to have a catchphrase that would immediately trigger deep emotions and deep historical roots of the legal systems of judges around the world. And we all are familiar from day one in law school with the principle in dubio pro reo in criminal law. So in case of doubt, don't convict the defendant, in other words. So this in dubio pro aqua is probably the most cutting edge novelty in this text, because it didn't exist before. You are not going to find it in any piece of literature, in any case. So I end here, it's 10 minutes, and I call the attention of the participants to a publication that the Environmental Law Institute did just before the forum and for the forum, with texts from some of the judges that participated in this group that draft the Brazilian Declaration. And here is the publication. It's the Environmental Law Reporter, News and Analysis. It's the March 2018 edition. And there are articles there by several of our colleagues, including Scott Fulton, the president of ELI, Ricardo Lorenzetti, Luc Lavricien, Emmanuel Ugirashibuja, Michael Wilson, and in the following issue, an article by Justice Brian Preston. So I stop here. Denise, I went 1 minute beyond my time because I wanted to show the publication of ELI, and perhaps ELI can give to the organizers those individual articles, and you, Professor Antolini, can then attach to the video of the different presentations. Many thanks.
Wonderful. Thank you so much, Antonio, for joining us and providing us that excellent background. Nobody can tell that story except for you. It's an amazing, unique story about how it all unfolded. Stefano, I'm going to turn it over to you to introduce our panelists and to continue the conversation about the principles in the Declaration. Stefano.
Yes, thank you, Denise. And allow me to again extend a warm welcome to whoever is watching this webinar. We heard some very inspiring words from Justice Benjamin regarding the background and of the Brasília Declaration and how the declaration came about. And I had the honor and the privilege to be actively involved in the conceptualization and drafting of it. Now, this webinar is in fact about the Brasília Declaration of Judges on Water Justice. Now, let me put some and provide some perspective to this webinar, and perhaps provide also the direction and purpose of the webinar before I introduce the panelists and give the floor to them. Now, the freshwater resources of planet Earth are coming under increasing stress due to a multiplicity of factors, and most notable among them, no need to mention it, are the effects of climate variability, climate change. Now, against this backdrop, the governance of water resources has attracted increasing attention. However, the legal discourse about governance has tended to polarize around the role of parliaments as regards the conceptualization, the drafting, and the enactment of laws, acts of parliament, and the role of governments with respect to the implementation of the laws that are enacted by parliament. We are talking about water laws in the specifics. Now, the role of the judiciary in the interpretation, in the application, and in the eventual enforcement of the laws, of the water laws enacted by parliament and implemented by government has gone by and far, in my own judgment, amiss in the discourse about, in the legal discourse about the governance of freshwater resources. Now, the Brasília Declaration is an attempt to fill the gap by zooming in on the role of the judiciary and offering at the same time articulate guidance and inspiration as regards the wider water governance backdrop, but also the wider ecosystemic dimension and ramifications of the function of judges and of prosecutors as they deliver water relevant and, more broadly speaking, environmental justice in civil, administrative, and criminal cases. Now, as Justice Benjamin has mentioned and illustrated, the Brasília Declaration emanates from and is informed by the experience of a large group of justices and prosecutors who gathered at the World Water Forum 8 in Brasilia in March 2018 at the initiative of WCEL, and in particular, under the guidance of Justice Benjamin, in representation of different legal systems of the world, and in response to their own, the participating justices and prosecutors' awareness of that wider context that I alluded to a few minutes ago. Now, against this backdrop, this webinar will offer a reading by 3 judges from respectively Australia, Chile, and Kenya, and by a water and environmental advocate from Colombia, of the Brasília Declaration principles in the case law that they have either handled personally in their role of judges, or that they are familiar with by virtue of their work, either as judges or in the position of one of the panelists who comes from academia, Dr. Maria del Pilar Garcia. Now, the ultimate goal, what is the ultimate goal of the seminar, of the webinar, is to bear out on the one hand, the emerging role of judges and prosecutors as water and environmental stewards, if I may use the term, but also as the guardians of last resorts of the stressed freshwater endowments of planet Earth, and B, the inspirational value and relevance of the Brasília Declaration principles in that context. Now, without further ado, let me now introduce the panelists. We have the Honorable Justice Brian Preston from Australia. He is the Chief Judge of the Land and Environment Court of New South Wales. Prior to being appointed in November 2005 to that post, he was a senior counsel practicing primarily in New South Wales on environmental, planning, administrative and property law. He has lectured in postgraduate environmental law for nearly 30 years, and he is the author of Australia's first book on environmental litigation and author of much more, many more articles, book chapters and reviews. He is a member of various international intergovernmental law committees and advisory boards, including in particular the Interim Governing Council of the Global Judicial Institute on the Environment, and has been actively involved in the drafting of the Brasília Declaration. We have with us also the Honorable Justice Oscar Angote, who is a judge in the Environment and Land Court in Machakos, Kenya. Justice Angote holds a Bachelor of Laws and Master of Laws in Environmental Law from the University of Nairobi, and is currently a PhD candidate in Environmental Law at the Center for Advanced Studies in Environmental Law and Policy at the University of Nairobi, and has published on a variety of environmental law issues. In the order, we have next Dr. Maria del Pilar Garcia, who is Professor of Law at Externado University in Colombia, and a leading academic scholar as well as practitioner in the fields of water and environmental law. And she also serves as Director of the Environmental Law Department at Externado University. Last but not least in the order, we have with us Dr. Michael Handke Domas of Chile. He's a Chilean lawyer specialized in environmental law, economic regulation, and antitrust. From its creation in 2013 until September 2019, he served as Justice of the Third Environmental Court in Valdivia, Chile. Dr. Handke Domas today works as a lawyer, international consultant, and university professor. He has authored numerous academic publications and has been actively involved in the drafting of the Brasília Declaration. We have fortunate to have with us a very robust panel of specialists, at least two of whom have had direct experience in the crafting of the Brasília Declaration. Let me now turn to the Honorable Justice Brian Preston to deliver his presentation. Thank you.
Thank you very much for participating, allowing me to participate in this. You might find my video breaks up, but hopefully the voice will come through. That's just a product of the bandwidth in Australia at the moment. I've got a presentation where I'm going to focus on 4 of the principles, the 10 principles in the Brasília Declaration on Water Justice. So the first slide, I've set out the key features of those, some of which Justice Antonio Benjamin did refer to. I'm going to focus on 4 of them, which is on the next slide. Water stewardship, the prevention principle and precaution principle, which I'll deal with together, and then good water governance. What I wish to do is to show you how these principles have been applied in one jurisdiction, and that's in Australia, and particularly in my jurisdiction of New South Wales. So the first one is this principle 1, and I'll just read it for people who are listening. So the state should exercise stewardship over all water resources and protect them in conjunction with their associated ecological functions for the benefit of current and future generations and the earth community of life. Now we can see there are 2 aspects in this particular principle, shown on the next slide. So one is looking at water being a public good, and the fact that governments should be exercising stewardship over these water resources for the benefit of the public. A second aspect that I'll come to later is about the intergenerational equity, and that is that this exercise of stewardship is not only for the benefit of present generations, but also for future generations. So where have we seen this in Australia? We've seen it particularly looking at this idea that water is a public good. So a little bit of history here. One is Australia is a common law system, so we inherited our law from England. And at common law, a person who lives next to a river is entitled to use that water. But interestingly, in Australia, perhaps because it is the driest continent in the world, these common law rights were at a very early stage, in pre-colonial stage, abolished by water legislation. So in the next slide, we can see that I'm picking up what has happened with that legislation. And I'm quoting from one of the pieces of legislation, but it's typical. And that is that the right to the use and the flow and to the control of the water in all rivers was vested in the government, the state crown. Now, the vesting of the rights in the crown was an exercise of sovereignty of the state. And that exercise of sovereignty included the right to issue licenses to people to take the water. Now, what's interesting about that legislation is it didn't disturb a common law notion which came through from Roman times that water is a common property and that it's not amenable to private ownership. And that's why it should be vested in a sovereign state. So we see this in the public trust, in the concept that running water is part of the public trust. But I've quoted there from Sir William Blackstone, very early, you can see 1766 commentaries on the laws of England, that water is a movable, a wandering thing, a must and necessity continued common by the law of nature, so that a person can only have a temporary, a transient, or usufructory property therein. Now, groundwater is treated similarly in Australia. So it was a little later, the legislation, but the legislation also said that the right to use, to the use and flow and the control of groundwater was vested in the Crown. And that power of the Crown over groundwater includes the power to issue licenses to tap into and take the groundwater and to restrict the amount of water taken. So how have these come up in cases? Well, I'm just giving you one of the cases, and this went to our highest court. And the question was, when the government worked out that it had over-allocated the licenses to take groundwater, far more than the system could cope with, they then reduced those allocations. And there was a challenge saying that the reduction in the people's allocation to take groundwater was an acquisition of property, which is contrary to the Constitution, and therefore there should be just terms paid. Now, the High Court unanimously, or except for one judge, rejected that challenge, and they did so on slightly different bases. Three of the judges said, well, because groundwater was a natural resource, and therefore it was part of that public trust, and the state had the power to limit the volume of water to be taken from that resource. In other words, it wasn't individual property. The other three judges said it was also, there was no acquisition of property, and they gave a few different reasons. One was the fact that it was the fugitive nature of groundwater, that it was moving, which actually gives it aspect of public trust. The other aspect was that water licenses are a creature of statute. And so that's why I said they abolished any common law rights to water, groundwater, but created this control over water and the ability to give licenses by statute. But interestingly, the third reason was that in fact groundwater could never be the subject of property at all, and therefore said that any rights in groundwater are vested in the state, and their statutory rights to controlling access to a public resource. So we can see through that case that this concept in the first of the Brasília Declaration principles of it being a common good comes through. The other aspect of principle one is this concept of intergenerational equity, and that is that governments have this responsibility to exercise stewardship over the water resources for present and future generations. One case in which that's been considered was a case in Queensland on the next slide. And if I get the next slide, there we go. And this was a mine which was going to tap into underground aquifers and lead to serious depletion of the groundwater. And the court determined that the impact, not only on present generations, but on future generations, was unacceptable and recommended the refusal of that particular coal mine. On the next slide, you can see, unfortunately, the coal mine did go ahead and is causing a considerable impact. I come to the next two principles, and they are principles 4 and 5, one dealing with prevention and the next dealing with the precautionary principle. I set those out in the next slide. So the first one, the principle of prevention, is primarily focusing on that we should prevent harm happening in the first place rather than waiting for the harm to occur and trying to remediate it. The next principle is a common one around the world, and that is the precautionary principle, and that judges should uphold and order the taking of necessary protective measures having regard to best available scientific evidence where there is this risk of serious or irreversible harm to water. So the Rio Declaration underpins that principle 5 that we have in the Brasília Declaration. So the precautionary principle is well known. I'll come to it in the next slide. Once it's activated, we have to determine what should be done. And that involves an assessment of risk, where you look at the probability of the particular event occurring and the seriousness of the consequences should it occur. Obviously, the more significant and certain the threat, the greater the degree of precaution required. Now, we can look at the cases in Australia, and we can see that there are at least 4 different ways the courts have taken action to prevent harm applying the precautionary principle. That's in the next slide. So one is to obtain further information. The second is to allow a margin for error. A third is to adopt an adaptive management approach. And the fourth is to prohibit the development, which really embodies the preventative principle. I'll give you some examples of these responses. So in this case, there was a proposal to build a road which was going to go through a creek line, waterway, and which was the habitat of a particular frog that needed to live in that waterway. In the next slide, we can see the issues were there was uncertainty about the frog. This is quite typical, of course. When you've got endangered species, there's a dearth of knowledge about the particular species. And the question was, should the road be built when there is this uncertainty? And the court determined that it shouldn't be, that a precautionary approach was to obtain further information to reduce that uncertainty. In the next slide, I deal with the second approach, and that's allowing a margin for error. Now, we all know about environmental impact statements. A species impact statement is a similar type of environmental impact assessment, which is done for threatened species. In this case, there was a particular threatened species of snail which lived in a water-dependent ecosystem, a swamp forest, and it determined that the precautionary principle should err on the side of allowing this higher degree of environmental impact assessment. In the next slide, there's another example of two more frogs, which are threatened species, and again, the court erred on the side of having that higher degree of impact assessment. In the next slide, we can see the third of these approaches, and that's an adaptive management approach. In this case, there was a proposed limestone quarry, but there was a real risk that there would be fissures and caves within this limestone formation where rare stigofauna or cave-dwelling biota might live. So the court, in the next slide, we can see adopted an adaptive management approach, and that was a step-by-step approach to measure what the impact was before allowing the next step and then having a feedback loop. On the next slide, the last of these ways, and this is really the preventative principle, is the best option may be to prohibit undertaking the particular action. So in the particular case I referred to on this slide, there was a critically endangered ecological community, a freshwater wetland community, which would be removed by the particular development, but over time, there was only a real risk that the whole of the wetland would be removed. So the court then prohibited that particular development. On the next, there's a photo of the slide of the particular area. In the next one, there was a groundwater extraction. And again, because of the uncertainty about the underground aquifer, it was decided to prohibit the continued extraction of groundwater. That brings me to my last one, which is about governance. And so principle 8, I've set out on the slide, and it's about having good water laws and the effective implementation of those laws. So I'll just deal quickly with the next one. And we go one more slide forward. There needs to be compliance, and sometimes people say that we don't have the financial resources to ensure compliance. And I have two cases, which in the slides, where the court frowned upon that approach and said the obligation is to ensure compliance with the laws to ensure that there is not a pollution of waters. So that was the first case. And then the second case on the next slide, it was again another government authority where the court said that there needed to be this budgetary and financial and management allocation to ensure compliance. And then the other aspect is that if water is to be used, there should be proper charging for water so that it's not wasted. And that ensures metering for it. So I've got a couple of cases in the next slides where there was prosecution for irrigators failing to meter and record the water that they used and therefore abuse the system. That was one case. In the next case, the Barlow case, was another one where the metering equipment wasn't used and they extracted water. Just to show you the size, that is one of the areas which is huge. You don't quite get an idea of the size of these irrigation properties, but there's a lot of water being taken out in times of drought in Australia. So that concludes what I wish to say, but it gives you some insight into this concept of water justice that is part of the Brasília Declaration. And there is this responsibility for judges to think about these 10 principles and see how they can be implemented in their judicial decision-making. Thank you.
Thank you, Brian. Thank you very much for this very entertaining reading of the Brasília Declaration principles in your own, experience as a judge. May I now turn to and call on to Justice Oscar Angote from Kenya to please deliver his own presentation. Oscar, you have the floor.
Thank you very much, Stefano, and my dear panelists and viewers. My paper will examine the progress and contribution that has been made by the Kenyan judiciary to ensure environmental rule of law, more so on water justice, the key concepts. And those concepts that I'm going to look at are geared towards the concept of water justice and the Brazilian Declaration. The paper will examine how the judiciary in Kenya has contextualized and applied the Brasília Declaration of Judges on Water Justice, either directly or indirectly, to attain water justice. As an introduction, attaining water security and sustainable use of water resources is critical, especially in this particular century. And in 2010, in September, the UN Human Rights Council affirmed the right to water and sanitation. Now, the Brazilian Declaration of Judges on Water Justice, which was adopted at the 8th World Water Forum, recognizes that water justice involves environmental stewardship, intergenerational equity, sustainable ecological and customary rights, and so many other declarations and principles that my brother Justice Brian has looked at. Now I'll look at the next slide, which provides that despite substantial progress having been made in increasing access to clean drinking water and sanitation, we have so many people, mostly in the rural areas and in Africa in particular, who lack this particular basic need. And this particular basic need has become even more important during this COVID-19 pandemic, which has actually demonstrated the critical importance of sanitation, hygiene, and adequate access to clean water for preventing and containing diseases. Now I'll look at the first principle, that is the principle which requires states to exercise stewardship. That's the principle, the first principle of the Brazilian Declaration. The principle requires states to exercise stewardship over all water resources and protect them in conjunction with their associated ecological functions for the benefit of the current and future generations and the earth community of life. The principle supports the assertion that water is a public good and that governments should exercise stewardship over water resources for the benefit of the public. Pure public goods, of course, have two defining features. They are non-rivalry and they are also non-excludable. So that what that means is that a person's enjoyment of a good, which is an rivalry, does not diminish the ability of another person to enjoy the same good, just like air. Therefore, the increased entrenchment of human rights approach to judicial spheres in this area of what had been a public good is now recognized internationally, regionally, and nationally to secure and clarify that right to water in case of violations. The Kenyan Constitution requires affirmative action to ensure that all minorities and marginalized groups have access to water and sanitation. And although the state owns all water resources, the Constitution has devolved the provision of water in Kenya and the sewerage services to the 47 county governments. States, as we all know, have an obligation to efficiently utilize all available resources at their disposal. And the issue of devolution of water and how that devolution has affected the right to access to clean water and sanitation vis-a-vis the county governments has played out in the Kenyan courts. And I've cited one case, that is the Murang'a County government versus the Murang'a South Water and Sanitation Company Limited, where the court held that a water service provider, which in this case is more or less a public limited liability company, could not approve water and storage tariffs in the county without getting the consent of the county government. In this contest between some of these companies and the county government has actually had an effect on the right to clean water and sanitation. Now, on the issue of water being a public good and which should be provided by the government, the court in the Kappa Oil Refineries Limited case versus Export Processing Zone Authority reiterated the 2010 United Nations General Assembly Declaration of Safe and Clean Drinking Water and Sanitation as a human right under international law. In the said case, the Kappa Oil Refineries case, water and sanitation was recognized as a singular, composite, and independent right obligating states to ensure the provision of water and sanitation to its people. The state in this particular case was obliged to provide resources, including developing infrastructure to scale up efforts to provide safe, clean, and affordable drinking water and sanitation to all. The court also addressed the issue of commodification of water and stated that commodification of water was undemocratic and centralizes the control over decision-making and resources, thus destroying natural resources and eroding democratic base of politics. On the issue of privatization, the Kappa Oil Limited case stated that under the Water Act of 2016, water actually belongs to the state and it is to be managed and supplied for the benefit of the people, and that the negative effects of privatization of the provision of water and sewage services points to the contrary. The court in the Kappa case further stated that privatization of water and sewage services does not benefit the marginalized and vulnerable groups at all. This decision lends credence to the Brazilian Declaration's first principle, which states that the state should exercise stewardship over all water resources for the benefit of the current and future generations. And in effect, Principle 1 of the Brazilian Declaration, which addresses the issue of inter and intergenerational equity, has actually been upheld in that particular decision. Now I'll look at the next slide, which addresses the principle, the second principle, or the Brasília Declaration, that acknowledges the duty of water users to sustain the ecological functions of water resources. And this principle is in the previous slide, that is the previous slide, where we have the case of Friends of Lake Turkana Trust. Yes, this particular slide. Now, the Friends of Lake Turkana Trust versus the Attorney General is a matter where the petitioner argued that Ethiopia's plan to construct two dams, that's Gibe Dam 2 and 3, upstream along the Omo River, will significantly affect Lake Turkana, which offers livelihood, food, and drinking water to nearly 300,000 people, and which will affect the heritage of the people living around that lake. The petitioner sought for an order from the court to stop the government of Kenya from entering into any agreement with the government of Ethiopia relating to the proposed purchase of 5,000 megawatts from Gibe 3. Now, as we all know or ought to know, Omo River is one of the biggest rivers in Ethiopia and is entirely contained within the boundaries of Ethiopia and empties its waters into Lake Victoria, and Lake Victoria is in Kenya. And it's on the border of Kenya and Ethiopia. Now, Lake Turkana in northern Kenya is the world's largest permanent desert lake and the world's largest alkaline lake. Lake Turkana is also on the list of UNESCO's endangered World Heritage Sites, and therefore ecologically is one of the most important freshwater lakes. Now, after receiving evidence on the issue of whether indeed the construction of the two dams will have an effect on the people who rely on that particular lake, the court found that the petitioner had shown that the harnessing of electricity from Gibe Dam 3 in Ethiopia is likely to affect the right to life, livelihood, and cultural and environmental heritage of the people depending on the lake. The court further directed, I'm still on the previous slide, the court further directed the government of Kenya to take the necessary steps and measures to ensure that the natural resources of Lake Turkana are sustainably managed, utilized, and conserved in any engagement with and in any agreements entered into with the government of Ethiopia relating to the purchase of electricity from Gibe Dam 3. Now, the next slide also looks at the other case of the Luo Council of Elders and 8 others versus the county government of Bomet and 24 others. This particular case considers the importance of indigenous and tribal people's rights to the conservation of ecological and hydrological functioning and integrity of water resources in the country. In this particular case, the indigenous people living downstream in Kenya along Sondomiriu River and Itare River argued that the construction of Itare Dam along the Itare and Sondomiriu rivers will affect the hydrological functioning and integrity of the water and related ecosystems in the entire water basin. The petitioners sought to stop the construction of the dam, and after receiving evidence, the court actually agreed that it is important for the hydrological ecosystem of the water basin in question to be maintained, but found that the petitioners had not established that indeed the government of Kenya had flouted that particular requirement by holding that only 6% of the total Sondomiriu water catchment area will be affected by the construction of the dam, while about 4% of the water flow from the Itare River will be utilized for the dam, and that the water flow of the river will not be significantly interfered with, and that the dam will harvest and store flood water from the rains, and an environmental water spillway will ensure there was uninterrupted water flow downstream throughout the year. The court therefore was of the view that the government of Kenya had taken into consideration the ecological functions and integrity of water resources, which, as we all know, are supposed to be protected by the upstream users, and therefore dismissed that particular complaint by the petitioners. Now, my next slide looks at the principles number 5 and 6. These are principles dealing with water justice and the precautionary principle, which Justice Brian has explained. The precautionary principle is one of the most popular and commonly applied of the principles of ecological sustainable development. The principle is based on Principle 15 of the Rio Declaration on Environment and Development, and it provides that states should widely apply the precautionary principle in order to protect the environment. According to the precautionary principle, where there are threats of serious or irreversible damage, lack of full scientific certainty should not be used as a reason for postponing cost-effective measures to prevent environmental degradation. Now, the principle has been applied in Kenya alongside the principle requiring that environmental justice should be upheld in water disputes. And the case which actually dealt with this particular principle was the county government of Kitui versus Sonata Kenya Limited and 2 others. In this particular case, what happened is that a private person intended to bury asbestos in Kitui County on his piece of land after winning a tender to do that and getting a license. However, the county government of Kitui raised an objection on the basis that the asbestos were going to be buried somewhere near a water catchment area. And therefore, they objected to the burying of the asbestos, whose effects we all know. Now, the court, after receiving evidence, stated that it is not plausible to argue, as the respondents had argued, that there was no evidence to show that the asbestos are likely to degrade the water catchment area. The court held that under the precautionary prevention principles, lack of full scientific certainty of what will happen to the underground water cannot be a reason for the court to issue interim conservatory orders. Water justice, as I finish, just like environmental justice, entails the right to have access to environmental information, public participation, and involvement of the people in decision making. This particular principle of water justice has been reinstated in numerous decisions of the court, including the Lake Turkana case, which I've already alluded to, and in which the court observed as follows: the court is alive to the right to access of information, which is provided under Article 35 of the Kenyan Constitution. And the court further said that public participation can only be possible where the public has access to relevant information and is facilitated in terms of reception of views. The court stated that access to environmental information is therefore a prerequisite to effective public participation in decision making. In conclusion, water justice examines the issues of procedural equity and access to the process of justice in the utilization of fresh water. The necessary policies, legal and institutional framework are crucial in ensuring that water justice has been attained in a uniform and consistent manner. The courts in Kenya have been consistent in upholding the internationally accepted principles meant to attain the principles of water justice, including the Brasília Declaration of Judges on Water Justice. There is therefore need to further develop jurisprudence on these particular principles through judicial capacity building, sensitization of the masses on their right to clean and safe water, more stakeholder engagement through deliberate, holistic, and integrated strategies. Therefore, the right to clean and safe water will be protected in all spheres and in accordance with the Brazilian declaration by the judiciary in Kenya. And of course, the Environment Land Court of Kenya has one or two things to learn from the New South Wales, which actually provides a great example of how they have applied these particular principles. And that's the end of my presentation. Asanteni sana.
Thank you, Oscar, for your brilliant presentation and again, reading of Brasília Declaration principles in the work of the courts, in the judgments, selected judgments in Kenya. You've attracted attention, rightly so, to the human rights dimension that is also in the Brasília Declaration. And I like, in particular, caught my attention, your the application of reading, if you like, of Brasília Declaration Principle 2 in particular, in respect to the government of Kenya as opposed to individuals or corporations. And I think that is an extremely interesting application, if you like, of the Brasília Declaration, reaching out to the government or governments as opposed to, as guardians and stewards of water resources, as opposed to individuals and corporations. Now, let me turn now the floor to Maria del Pilar Garcia for her presentation. Maria, you have the floor.
Thank you. Buenos días para todos y muchas gracias por esta invitación. Hoy quiero hablar con ustedes un poco sobre el reconocimiento de los derechos de los ríos en Colombia como una forma discutible de justicia hídrica. Para ello, quisiera empezar por hacer una breve introducción. Esta introducción quiero referirla especialmente a dos factores. El primero, reconocer que en América Latina existe una crisis del agua. Esta crisis del agua está generada por diferentes situaciones. La primera situación que quiero resaltar es que a pesar de tener una cantidad importante de agua, tenemos diferentes escenarios en donde hay escasez. Existen asimetrías importantes en lo que tiene que ver entonces con oferta y demanda de recurso hídrico, así como diferentes dificultades sociales y económicas que también generan asimetrías. Hay deficiencias importantes en el acceso a agua segura y de saneamiento, y existe dificultades también en el tratamiento de aguas residuales en América Latina. Para poner un ejemplo, en Colombia solamente se trata del 48% de las aguas residuales municipales, lo que nos pone en un escenario realmente difícil en lo que tiene que ver con la calidad del recurso hídrico en el país. A todos estos problemas, a todas estas problemáticas debe añadirse también la presencia de actividades ilegales. Estas actividades ilegales afectan recursos como el recurso forestal, pero también afectan la explotación de diferentes materiales y consecuentemente traen también afectaciones sobre los ingresos que se deberían recibir por parte del Estado por el acceso a estos recursos. Uno de los mayores problemas que también tiene la región en lo que tiene que ver con el agua es el escaso cumplimiento de la ley. Este escaso cumplimiento de la ley se da inclusive en actividades que podríamos calificar como formales y en algunos sectores donde no hay conocimiento pleno de la norma y algunos actores entienden que esta falta de conocimiento los exime. Situación que para a todas luces afecta también el manejo del agua en la región. Tengo que hacer referencia igualmente a un fenómeno que se da en la región, que se da en mi país, es el de la corrupción. Diferentes recursos económicos que han sido destinados para el manejo adecuado de las aguas no logran destinarse a este lugar. No logran efectivamente llegar a los espacios del país que necesitan diferentes obras, diferentes infraestructuras para mejorar su acceso al agua potable y al saneamiento o el tratamiento de las aguas. Todos estos factores entonces hacen que podamos decir que en la región hay una débil gobernanza de las aguas. Con estas debilidades, con estos problemas, con esta crisis del agua, pues cada vez tenemos más conflictos alrededor de ella. Si miráramos, por ejemplo, los datos de el Atlas de Justicia Medioambiental, encontraremos que hay 3.200 casos reportados hasta ahora. De esos 3.200 y tanto casos que reporta el Atlas, si hiciéramos un filtro con el descriptor agua, encontraríamos que muchos de ellos tienen relación con afectaciones al recurso hídrico. Estamos hablando de minería, energía, infraestructura, agricultura. Vamos a encontrar que existe relación de estos conflictos con el agua. Con este número creciente de conflictos, al juez le ha correspondido de manera creciente desarrollar acciones, desarrollar soluciones para lograr solucionar el conflicto. En el caso colombiano, existen diferentes jurisdicciones, pero son particularmente la jurisdicción constitucional y la jurisdicción administrativa, aquellas que se dedican a la solución de los problemas que tienen que ver con el agua. Desde la perspectiva constitucional, un enfoque que ha venido tomando cada vez más importancia en la región, pero particularmente en Colombia, es el enfoque ICAL, que habla de Ius Constitucionale Común en América Latina, derecho constitucional transformador en América Latina, un enfoque de derecho constitucional fuerte que pretende la transformación, que pretende el cambio de la sociedad, pretende romper barreras que se han constituido, ya sea por formas de poder, por burocracia o por dificultades administrativas que se construyen en muchos casos para tratar de privilegiar a ciertos sectores. Es el juez entonces el que está encargado de realizar esta transformación y de lograr así la protección de los derechos humanos. Esta protección de derechos humanos permitiría alcanzar todas las promesas que han sido identificadas a escala constitucional y que hasta el momento pues no han logrado consolidarse. Desde la perspectiva de la jurisdicción administrativa, que ha tenido un enfoque clásico de permitir que sea la herramienta de sujeción del poder público a la ley, también se han logrado diferentes alcances o diferentes logros en lo que tiene que ver con justicia hídrica, en particular porque a través de las herramientas de control judicial del gobierno y control administrativo de la propia actividad gubernamental, se ha logrado dirigir, consolidar esa acción gubernamental hacia la protección del recurso hídrico. En particular, a través de acciones populares, se ha permitido una manifestación expresa del juez para lograr también transformaciones. Estas formas de justicia ambiental en Colombia realmente han sido importantes y han procurado avanzar hacia la justicia del agua. Creemos que la declaración de Brasilia, que ya mis antecesores han comentado, es una fuente muy importante para los jueces, una fuente de derecho que debe ser consultada de manera permanente por los jueces cuando estén tratando asuntos que tienen que ver con el agua. Hay dos puntos dentro de la declaración que me parecen sobresalientes. Uno de los puntos es reconocer que el derecho de aguas, el derecho ambiental son esenciales para lograr la protección de los recursos hídricos, y otro de los argumentos de donde parte la declaración es que es muy importante que se tenga el conocimiento y la información necesaria para poder solucionar los conflictos que se le presentan al juez y para contribuir con soluciones efectivas. Dentro de los principios ya nombrados por mis antecesores, hay algunos que creo que son de particular importancia, sobre todo para discutir con ustedes brevemente los casos de reconocimiento de derechos a los ríos que han venido dándose en mi país. Los principios a los que quiero hacer referencia en particular son los principios 3, 5 y 7, que hacen referencia a la necesidad de reconocer la importancia de los pueblos indígenas en estos que están ubicados en espacios relevantes para el recurso hídrico, el principio 5 que nos habla de precaución, que también ha sido nombrado por otros de los conferencistas, y el principio 7 que es el principio de contaminador pagador. ¿Por qué creo que son importantes estos principios? Porque de alguna manera creo que en algunas de las decisiones de reconocimientos de derechos a la naturaleza que se han dado en Colombia, pues ellos no han sido puestos o argumentados de suficiente manera para lograr la protección efectiva de las aguas. Me explico a continuación. El problema que se da con algunos de los ríos más importantes del país, como los que ustedes ven referenciados en esta pantalla, es un problema de contaminación. Problema de contaminación que ha sido causado por actividades legales e ilegales. Actividades que han terminado generando afectaciones importantes a la calidad de las aguas y consecuentemente a las personas que viven alrededor de ellas, que viven en la cuenca de estos espacios hídricos. La solución lógica que se pretendería lograr a través de la decisión del juez es ordenar la restauración medioambiental, mejorar la calidad de las aguas. Los fallos, especialmente el fallo del río Atrato, que es una de las piezas centrales en este reconocimiento de derechos a los ríos, han argumentado las decisiones o las órdenes que se han dado de descontaminación con fundamento en diferentes puntos, como por ejemplo la protección de las comunidades, la protección del derecho de las futuras generaciones, la protección del derecho humano al agua, el ecocentrismo, el principio de precaución y por supuesto el derecho humano al ambiente sano. No obstante, paralela a la decisión del juez de ordenar la descontaminación, el desarrollo de planes y demás, se ha incluido la declaración de los ríos como entidades sujetos de derecho a la protección, la conservación, el mantenimiento y la restauración a cargo del Estado. Esta decisión, esta declaración, aunque tiene toda la legitimidad, porque por supuesto el juez podría hacerlo, carece, a mi juicio, de la argumentación suficiente para hacerla efectiva. Y lo digo, esto después de analizar con primer tiempo o con una escala corta de tiempo los efectos de las sentencias. ¿Qué barreras hacia la efectividad encuentro yo en la declaración? El uso impropio del principio de precaución. Como lo han dicho también algunos de los conferencistas que me han precedido en la palabra, el uso del principio de precaución debe darse para escenarios donde hay falta de certeza científica y necesitamos tomar unas medidas para evitar el daño. En los casos en donde ya existe un daño consolidado, donde se ha probado el daño al interior del expediente que está analizando el juez, el uso del principio de precaución no tiene un sentido lógico. El sentido del principio de precaución es el de evitar el daño y no debería utilizarse el mismo para casos en donde el daño ya está probado. Otro falla argumentativa importante es no usar el principio de contaminador-pagador, principio que tiene que ver muchísimo con casos en donde efectivamente hay contaminación y donde es necesario identificar quién debería soportar el mayor peso en la condena del juez. Otra falla de argumentación es la creación de nuevas categorías legales sin argumentar el porqué de la categoría y cuál va a ser el alcance. El juez puede crear, pero es importante que articule esta creación jurídica con las herramientas normativas existentes, de manera tal que cuando se dé las órdenes por parte del juez, ellas puedan ser cumplidas por parte de la administración o de aquellos sujetos que se ordena cumplirla en la sentencia. Las órdenes entonces deben estar articulados también con realidad científica, tecnológica e hidrológica para alcanzar su eficiencia. Con todo esto, uno puede concluir que el reconocimiento del derecho de los ríos puede ser una herramienta importante, pero es también importante construir esta categoría de derechos a la naturaleza y construirla en profundidad para poder lograr su efectividad. El juez puede transformar, puede eliminar estructuras, inclusive puede ordenar la acción de diferentes ramas del poder público para lograr esta justicia hídrica. La Declaración de Brasília es una guía que puede permitirnos alcanzar mejores decisiones y mejorar el manejo y la gestión de las aguas. La declaración puede guiar la acción del juez informando acerca de la necesidad de construir sentencias que reconozcan la importancia del agua, de la sociedad y toda la realidad alrededor del conflicto que es objeto de análisis. Las decisiones novedosas, especialmente aquellas que crean categorías, deben estar suficientemente argumentadas y analizadas por el juez. Esta creación de categorías en esta creación de categorías el juez tiene legitimidad, sin embargo, la decisión debe estar articulada, como ya lo dije, con el sistema para lograr efectividad. El juez debe especializarse, debe conocer muchísimo sobre el ciclo hidrológico, sobre derecho ambiental y derecho de aguas, además de otros asuntos relevantes. El juez que quiere transformar debe pretender también desbloquear aquellos límites que han construido el gobierno, inclusive el parlamento, para alcanzar la justicia hídrica. Finalmente, tengo que decir que el juez debe argumentar, definir claramente las acciones que se deben tomar para que con sus sentencias se logre una justicia del agua efectiva. Con esto termino. Muchas gracias.
Thank you very much, Maria, for this very intriguing presentation. Your critical reading of these recent judgments and of the Colombian court, constitutional court, that has attracted a lot of attention insofar as it gives legal personality, grants legal personality to entire water bodies, which is widely regarded as a sort of cutting edge, if you like, in legal thinking. And I appreciate your reading or your interpretation that you offered of that particular construct, if you like, in the light of, in the framework, against the backdrop of the Brasília Declaration. So with this, I will now give the floor, because we are running short of time, very severely short of time, and we're running actually overboard. So I invite whoever is still on with us to bear with us a little longer. I give the floor to Justice Michael Handke Domas, and then at the end of his presentation, I would like to leave room for at least one question, perhaps. Mike, you have the floor.
Oh, again, thank you very much, and thank you for this kind invitation. I'm really glad to be with you again today, and of course, really honored to be speaking after these three fantastic presentations, and our hosts as well, Stefano and Denise and Antonio. Thank you for this invitation. Well, and thank you for everyone who is watching us, 90 people there around the world. So it's fantastic. So today I would like to get into really deep issues about this Brasília Declaration, because it's not that I took part on the drafting with Antonio, Denise, Stefano, Owen McIntyre as well, and many people as well working on this. Because there's a lot of things hidden on the declaration that I really would like to share with you that are very, very interesting. So today I will talk with you giving you some considerations about the Brasília Declaration, especially in principles 1 and 9, which are not overlooked, but usually are very complex and not usually being given examples about this. And I will show you two very good examples that I believe are good examples in this part 2 of my presentation, which are the case law, 2 cases that are very interesting. Well, my considerations about the Brasília Declaration. Why I took principles 1 and 9 is because in between the lines, and particularly in principle 1, the mention about the environment and the interaction between water and the whole environment is very important. However, it's very obscure in terms that, as Maria del Pilar mentioned, we judges usually we don't use or we don't go further our realm of knowledge, and usually we rely upon experts to understand reality. So I will show you how you can overstep that that kind of threshold and to apply these principles in a very, very useful fashion. So the first paragraph of the declaration is very important. It's not a principle, but it's very important, because at that moment, the people agreed on be guided by the 10 principles in promoting water justice through application of water law and the environmental rule of law. So this is very interesting because from a civil law side, not a common law side, this is an agreement by judges. So this is not the law, right? So we have written laws in civil law countries. But though these are guidelines that we are going to use as fundamental principles in the promotion of water justice. So from a civil law side, we might understand that this promotion of water justice amounts to be a kind of a political side, which is not the case, as I will show you. Because this promotion of water justice is being done through the application of water law and environmental rule of law. So the idea of promoting water justice is very interesting. As is it not a legal concept in terms that that it means it's an institution of the law, but usually it's overlapping with other more political concepts like environmental justice, for example. In America, environmental justice means it's a whole movement about trying to balance the imbalances produced by society against certain groups of people. But in terms of justice, what we are doing in here is just to balance the scales of justice in terms of giving everyone the fair amount in specific cases. So this is the take on water justice. It's not a promotion of a political idea, but it's a promotion of this fairness in application of in water cases. But in order to construct that fairness, it's very important to be guided by these 10 principles. So what we are doing is applying water law, and we are going to have in mind this environmental rule of law. This concept being developed by, led by Antonio and a lot of judges around the world about what are the components of a whole system. Okay, so and the principles that we are having here, and this again from a civil law perspective, are principles. So they are helpers in the decision being made by the judge in civil law countries, because we have a lot of discussion, and I put some arguments here about what are Robert Alexi, Dworkin, and Hart understand. How do they understand the application of the law by the judge? And one of the most useful, and the one I like a lot, is Robert Alexi use of principle, this theory of principles. So the 10 principles of the Brasília declarations are principles that provide for optimization of the law, okay? They are not rules, but they are mandates of optimization of decisions. And now I will show you in cases after this first part. I'm going to give you some guidance on this. And this is in contrast of what, for example, Hart proposed in several years ago, that the judge, when there's no rule, the judge is at discretion in order to decide. Okay. So, and of course, there's no provision for non-liquid in this case. So, so the judge can produce the law. Whereas in civil law countries, it's very difficult. But using this idea of principle as an optimization tool will be a very useful heuristic tool for deciding cases. So we have this first principle, the idea that the state should exercise stewardship, but my main, everyone, most of the speakers have mentioned this principle, but my interest is put on this idea of ecological functions of ecosystems, because somehow we lawyers tend to miss the picture, thinking that the whole world is constructed upon rules. But when we overstep our comfort zone, we understand that probably the world is organized in some other fashion, and probably ours is the wrong way of understanding the whole world. So, so the connection between water and the ecosystem is very important, and the water has ecological functions that we as judges we can't forget when we are adjudicating cases. And that's why I mentioned principle 9. This is a complex principle, but I will try to explain why this is not that complicated. So environmental and ecosystem considerations should be integrated into application and enforcement of water law. So when deciding a case, judges should be mindful of the essential and inseparable connection between that water has with the environment and land uses. So we should avoid adjudicating those cases in isolation. So it's not just water law. It's water being part of an ecosystem. And why this is important? Because it helps in order to solve cases, okay? So this is the first part of my presentation, I think in the middle of it. Now I'm going to share you 2 case law that I picked that they are very informative for this application. One is a case that we decided in the court in Chile, and it's a bit old. And I took a rather new one that was decided by the Brazilian Supreme Court, which is very interesting as well. So this is my first case. This is a municipality against a landowner. And have a look at this picture. This is the case. This is a gravel pit, or used to be a gravel pit. So here you can see a large pond in here. So that was the gravel pit. So what happened? One day it started to pour rain, and one of the river banks collapsed. Okay, so the river was swelled, so the water pushed the riverside and it collapsed. So water entered, filled the whole gravel pit, and then overspilled in these houses. Okay. So the people sued the municipality with the people sued the landowner because of these damages that they suffer because of bad land use. And you might think, well, this is a very straightforward case for tort law. But I will show you that, again, it might be another specific case for environmental tort law. And why is this? Because when you see this case, you can put all the concepts of tort law in this case, and you can solve it. You have a damage, a real damage, you have a victim, you have somebody who has done the harm, and probably the breach of duty is there clearly. But I will show you how we use the case, how we use these concepts. Well, the riverbank collapsed, so the court took this concept of ecosystem services as an element for clarifying what is environmental damage. So in order to assess the damage, we use this whole analysis and, of course, this idea of ecosystem damages, ecosystem services. And now this is the normal gravel pit. This is 2002, and you can see that there's a lot of work here. So the riverbank is not that thin in here. And now this is the case after the collapse of the whole riverbank. So the court found that the breach of duty was in here. We used this idea that is embedded in the declaration that the ecological functions of the ecosystem here were damaged because the ecosystem services that riverbank provided were not maintained by the owner of the property. So we use that again, another principle from the Brasília Declaration, this idea of the ecological functions of property and the breach of duty of the owner of the land of not maintaining those functions. So that's why we condemn that. We condemn the owner to restore the riverbank to the same characteristics that existed before being harmed the riverbank. And then we ask for comparing with an environmental quality index to compare both situations with the harm and the harm being undone. This is the second case. This is Instituto Brasileiro do Meio Ambiente e dos Recursos Naturais Renováveis. My Brazilian is very good. Oh, IBAMA, and Alberis Nunes and others. This is a decision being written by Judge Antonio Benjamin. So it's very interesting because it's a bit cheeky sometimes, the decision. Of course, probably he might not agree with my lecture, my reading about his decision, but it's very important in terms of how it's related with the declaration. So we have here, it's a very easy case. It's just some people that build on protected land. And that protected land is a riverbank, okay? So according to the Brazilian law, you can't build on margins of rivers because particularly when they are protected areas, you can't build up on those areas. Okay, so but irrespective of that, there were a lot of constructions there. Just even a pharmacy, a bar, and some second houses for holidays, etc. So the institute requested the bar of the extensions not to build more and the demolitions of the illegal dwellings. The trial court decided that the illegal use of the riverbank and the wastewater being poured into the river amounted to environmental damage. Thence, the court orders the demolition of the illegal dwellings, and the Supreme Court upheld. So the interesting issues are the thinking of the court. And I took two important arguments in the decision. First, the idea that the area is under an absolute presumption of inviolability, which is very interesting because in the whole decision, the court provides for arguments in terms of protecting health, security, property, and welfare, but as well recognizes that the idea of environmental system services, and clarifies the interaction between these two elements of the law. So one is, it might be land law and land planning law, and the other environmental law, and how those are fitting together. How are the functions of the environment fitting together with the other areas of the life? And the court decided that there's an absolute protection of being provided by the law means that any damage accounts for its violation, this idea of in re ipsa, and the area of such protected by law, it's relevant, it's ecological health. There's a protection by the recognition that there's an obligation property in rem in this to these illegal occupants, so they have to demolish and vacate and restitute. And the right to a healthy environment and the right of housing, this is a very interesting discussion because one of the defense, they were saying, well, we are poor people and we need to live somewhere. And the court addressed this issue about how you balance these two ideas. And this is very important because when I have this little light bulb, there is no incompatibility between both rights. Social misery does not trump ecological misery. So there's a balance between different rights. It's very interesting how the court decided on in this case in terms of the ecosystem services. So this is my presentation. Thank you very much.
Thank you. Thank you very much, Michael, for this very compelling reading of a couple of critical Brasília Declaration principles in your own experience as a judge yourself, but also in a case, recent case from the Brasília Supreme Court, a Brazilian Supreme Court. Thank you, Mike. Thank you very much. Now, we are way overboard in terms of time, and I think we have time, how much? Maybe 10 minutes left for perhaps to allow, I would say, at least one question. I would like to, well, we have received a number of questions that have been pouring in and coming in from a number of participants, and I would like to address perhaps or to allow one particular question that has a general import and value that I may pose to turn to all the panelists, on this panel. There is a question that, to my mind, also sounds quite intriguing, and it deals with and addresses an issue that is embedded in the Brasília Declaration in one of the final consideranda, or the I think in the final considerations of the Brasília Declaration, that has to do with the education, the education of justices, the education of justices to environmental law, to water law. And the question is framed in terms, do justices in your respective legal systems, we have heard from Australia, Kenya, Chile, and Colombia, do justices in your respective legal system have to have some prior formal legal education in environmental law or water law when they handle and deal with cases that have to do with water resources or environmental protection? And so this is a question, to my mind, of general import and value that I would like to turn to our participants, all the panelists, to answer. So the question is there a prerequisite in your own legal system for judges who deal with environment or water to have prior formal legal education in these particular disciplines? Or if not, do you think it is advisable and useful for judges to have at least some training in these particular disciplines? So I turn the floor. I don't know how to do this, whether you want to answer one by one, but perhaps I could ask Judge Preston, who was the first speaker, and then we turn to Judge Angote, and then to Maria, and then finally to Michael, and then wrap this up. So perhaps, Brian, what is your take on this question? What is your answer to this question?
We have in Australia a number of specialists of environmental courts. To be appointed to the court as a judge, you don't need necessarily a environmental certificate. Some people have got training in environmental disciplines in addition to law, but not all. I personally had practiced in environmental law for 30 years before I was appointed, so I have had a lot of experience, but most people who are appointed have experience in environmental law. We also have in our courts non-lawyers, so scientists and water ecologists and other people who are appointed, and so they'll have other areas of expertise, but we don't have certification of skills as such.
Okay, thank you, Brian. Oscar, what is your take of the question? What is your answer to the question?
Thank you, Stefano, and for that question. In Kenya, the Environment Land Court is a specialized court which has the same status as the High Court. Now, judges in the Environment and Land Court are supposed to have first and foremost the same qualifications as the judges in the High Court, which is actually a court of equal status with the Environment Land Court. The Environment Land Court Act now also stipulates that in addition to the qualifications of a judge of the High Court, a judge to be appointed in the Environment Land Court should have or must have additional experience in environment and land matters. So in Kenya, it's a requirement that in addition to the general knowledge that judges have, if you want to be appointed in this particular specialized court, you must have experience in environment and land law. And those are the qualifications that the employer always looks at for the purposes of appointing judges in this specialized court. Thank you.
Okay, thanks a lot. Thanks a lot, Oscar. Maria?
Thank you, Stefano. No, in Colombia, there's no need to special certification about knowledge of environmental or water law. But all the judges know a lot about constitutional and administrative law, but not specifically about water law. There's no requirement about it.
Okay, thanks a lot. I will revert to this in my concluding remarks. Now, I would like to hear from Michael. Mike, what's the situation from your own perspective in Chile?
Well, in our country, we have environmental law courts. So in order to apply for the court, you have to have a formal studies on environmental law or administrative law as well. So you can do both. However, being a specialized court, however, when the issues go to the Supreme Court doesn't have a specialist in environmental law. I mean, people who come from this path of the judiciary. But it doesn't matter because you can Supreme Court judges can are specialized, so they are specializing because of the time being spent there. And one of the particularities in the case of Chile is that one of our judges is not a lawyer. So we sit in benches, sorry, in benches of 3 judges, and one of us is not a lawyer. In our case, it is an environmental biologist, so a marine biologist. So we decide cases in these benches of 3 judges, with one of us not being a lawyer, which is very useful.
Thank you, Mike. I take it from your answers, therefore, that a formal specialization comes with the existence of a specialized court or courts that deal with environmental cases. It sounds to me like this, which brings, however, in the forefront the issue of what happens elsewhere. Now, where you don't, or as Mike says, when you elevate the case to a higher level court that doesn't have the special knowledge that the environmental law court has in your particular case in Chile. So now in that, if we follow this line of thinking, so in your own experience and appreciation, what is the value of having, raising, if you like, the awareness and the education of judges in the legal system, where there are specialized courts, but cases, may be elevated to higher level courts that don't have that specialty. So what is the value? Is there value and meaning to, pushing for the education, awareness raising of fellow justices in your own respective legal systems? It's something I suspect that is trying a question that the Global Judicial Institute on the Environment is presumably trying to respond to and to address. What is your opinion on this, Justice Brian?
Picking me up. So look, we have continuing education about matters such as the water law and the Brasília Declaration to keep the judges up to date, and promote through conferences like this what the judges' knowledge is, articles, etc., so that the judges can keep up to date.
Okay, thank you, Brian. Oscar, what's your take?
Yes, just like Brian has said, we have in Kenya a Judicial Training Institute, whose mandate is to train judges on a continuous basis. And one of the areas that the Judicial Training Institute actually usually focuses on is this field of environmental law, because it's very specialized. And just like in Michael's country, even in Kenya, once the matter goes to the Court of Appeal, the Supreme Court, you'll find that the judges in those courts are judges dealing with general issues, and therefore training and sensitization on environmental matters to those judges is very, very crucial, and that's what is usually undertaken by the Judicial Training Institute. So it's an important area, and I think our judges, and even those judges in the specialized courts should continue being trained in this particular field. Thank you.
Thank you very much, Oscar. Maria, a quick view on this?
Yeah, I think the knowledge is important, the skill and the information relevant to water and environmental law is crucial to have good decisions, transforming decisions. So I think that the judges must study of the subjects to resolve all the conflicts that they have to.
Thank you so much. Michael?
Yeah, finally, well, I can agree with everyone. I think it's very important to be well educated in this matter, not just judges, but as well prosecutors and other participants at the courts, because the nuances of the environmental law is very deep. So this is my take.
Thank you very much. So thank you very much to all the panelists. I think we are way overboard with time. So I'm afraid, I cannot entertain more questions. I chose to zoom in and zero in on this particular aspect, if you like, on this particular question, I'm sorry, to highlight what to my mind is a crucial aspect which is evoked by the Brasília Declaration. The Brasília Declaration, as I said, comes from judges and justices and prosecutors who have shown acute awareness of the environmental dimension of their work by virtue of their own work, of course, but also by virtue of other pursuits, like in the case of Maria in academia. But it is very, I would say, critical that in order for the Brasília Declaration principles to be taken up by fellow justices, from different parts of the world, and to make a dent in delivering justice when it comes to the protection, the management, the conservation of freshwater resources, the ecosystems associated with it, and the environment in which water occurs is absolutely critical and very important. That's why I chose to dwell on this particular aspect, on this particular issue. Now, I thank all the panelists for a wonderful job they have done illustrating the Brasília Declaration principles from their own perspective, from their own hands-on experience and work. And I thank, obviously, all the participants, for their patience of bearing with us for a good solid 2 hours. I think with this, maybe I turn over to the webinar administrators, but I consider it closed, from a substantive standpoint. Thanks very much to everybody and to all concerned.
I would just add our thanks. We are so delighted everyone could join us. We will announce future webinars, and I think this was a most excellent webinar. The participation was terrific. The panelists were great. So with that, we say thank you to everyone, and we will wish you all well and see you at the next webinar, and we'll be in touch soon with some more information. Thank you.